gang investigators meeting in regards to investigative techniques and applying phone records and things like that.
And so I think you said, currently, do any investigators or detectives come to you to ask you about how to do this?
Yes.
And are you able to?
We're live, bro. Know what I'm saying? Everybody, good morning, good morning, good morning. We live, we live. We live. So, basically, we're going to review the So basically what we're gonna do is we're gonna watch it with him, but they in recess right now. So yo, what's up, bro? What's up? So we're gonna review. He got the new one, so we're gonna watch it with him once, you know, once the recess over, and I'm a stream for a little bit. So we're gonna watch this one for now. This is the one.
Explain how this cell site location information works.
Yes.
Okay. How often, and I know this is going to be a hard question, about how many cases have you done, would you guess, ballpark, cell site location information for? Ballpark is fine.
Over 100.
Okay. Have you ever testified as an expert witness in a case regarding cell site location information?
Just chill out for a little bit.
Okay. And how many times have you been qualified as an expert?
My fault.
7 or 8.
And what courts were those in?
Here in Fulton County and Cherokee County.
Okay. And what specifically were you qualified as an expert in?
The analysis of call detail records with historical cell site location information. So it's kind of a mouthful, but the analysis of historical cell site location information.
And finally, do you have any awards, commendations, or anything else that we haven't mentioned?
No.
Okay. Can you explain how cell site location information is generated?
Yes. So when we enter into a contract with a network provider, let's say Verizon or AT&T, we're issued our device as well as our unique subscriber information. Now, cell site location information CDRs with cell site location information originated more as more billing purposes. The providers needed to keep track of kind of what their clients, their activity was, only to really just maximize their product. They needed to know.
What is it doing, bro? Yo, cool.
To know, if they were getting dropped calls, and as well as how they were going to bill their client. It used to be a time when we would be charged for going over our minutes and more texts and things like that. So that's kind of how these records were initially created. So anytime that we make a phone call, a text, utilize data, it is tracked by the network provider. Has general information of date, time, who we're calling, and as well as which cell site or which tower enabled that cellular transaction, which enabled the connection to the network.
Okay. And so does this process generate information about locations when you do it correctly?
Yes. So depending on your carrier, they will provide in that particular record, you'll see the transaction, whether it's a voice or text, and then you'll see which tower was responsible for making the connection.
Okay. Now, how do you use this information when it's generated?
So at the request of law enforcement, we can see a particular number of cellular transactions through the call detail records, and we can generate maps based on that information, but also we can see the locations of the towers just through the spreadsheets that are provided with CDRs. From there, based on the relationships, based on neighboring cell sites, we can determine the general area of the device that utilize those towers.
Okay. Now, I know you mentioned a lot of trainings previously. Are there specific trainings that taught you how to do this method so that you can interpret and map out these cell locations?
Yes, the training with the FBI, the training with all of the private companies, Hawk Analytics, and prior training, yes.
Are the same methods used in all these by all these agencies that train you?
Generally, yes.
So is there sort of a generalized, like, specific method?
There's a generalized method, yes. Yes, of evaluating the records, mapping the records, and interpreting those records, yes.
Okay. And are there certain procedures for how to evaluate the data that you obtain?
Generally.
Okay. And can you describe the procedures that you have to use?
So typically when we receive the CDRs from the carrier, we will utilize it. I will go through and evaluate the data that's useful, and then I will utilize a mapping program to map those specific CDRs, and then go back and double check through, basically by hand mapping those records to verify that the locations were correct. And then, of course, using neighboring cell sites, you can determine a general area of a device.
Okay. And is this basically the main method that you've learned on how to extract this data?
Yes.
Okay. And has this method of mapping locations based on cell site location information, has this been tested for accuracy?
Yes. Agencies like the FBI will do drive tests to determine radio frequency relationships between cell sites and the devices. Carriers will also generate propagation maps which show radio frequency strengths and things like that. So it's generally accepted.
And if I'm understanding correctly, you can't pinpoint an exact location, but you can get a general location. Is that fair to say?
Correct.
Can you explain that a little bit?
Right. So based on CSLI, we're going to see the towers that are being utilized by the device, but we're not going to know the specific location of the device. So CDRs with CSLI will not, those GPS coordinates that you might see on them aren't the device. They're the cell site specifically. So we'll have a general area of where the device is based on the utilization of those towers, but we're not going to know, okay, that, it's at the corner of, Trinity and Pryor.
And has this method that you use, that you've learned how to do these, has this been published anywhere? Is it written down? Is it something that you learn in these trainings? Can you explain whether there's written guidelines or anything like that anywhere?
Yeah, mainly through trainings. That's where I've learned it. I believe the Scientific Working Group on Digital Evidence has also issued some recommendations, but this generally coincides with the same training that I have.
Okay. And if I understood you correctly, that's the same training taught by the FBI?
Yes, basically.
So that goes into my next question. Is this something that's regularly used by other police departments and federal agencies?
It is.
Can you name a few that might use it?
Atlanta Police Department, the FBI. Several agencies I've worked with when I was at APD. I don't know of an agency that isn't really aware of phone records and using them.
Fair enough. And do you know about how long cell site location information has been something that's accessible and been being used?
Well, like the cellular technology started in the late 80s. I would say that was probably the beginning of that type of technology and that type of documentation. As to a specific time when law enforcement started using them, I couldn't really tell you.
So I think you said you've been working with APD. You started working with APD in 2008?
Yes.
Was this something that was being utilized the whole time you were working with APD?
When I became an investigator, it's really, which was 2015, was really when I started seeing CDRs with CSLI, and I started working cases. It's not widespread. It wasn't widespread throughout Atlanta Police, but certain detectives would utilize them and be able to interpret them, and I would consult with them as well.
So would you say that this method? Do you know whether this method is generally accepted in the field of policing as a reliable investigative tool for determining an individual's whereabouts during a period of time?
General whereabouts, yes.
Okay. Were you provided with Javon Fleetwood's cell phone records
yes.
in an incident in this case?
Yes.
And did you use the principles that we just talked about when you evaluated those cell phone records and created mapping?
Yes.
Okay. And based on that, were you able to develop a report that included location information?
Yes.
Okay. Your Honor, at this point, we would move to qualify Investigator Worrell as an expert in cell site location information and data based on his experience, the many trainings that he's attended and taught, and his general knowledge of CSLI and how it works.
All right. Any cross? Anybody? Oh, sure. And you want to start the day off that way? Okay. All right.
Now, you're able to get cell site location information from the phone subscriber company?
Yes.
Okay, so you don't need defendant's actual phone to get that location information?
No, all you need is a phone number.
Okay, thank you. Those are my questions.
Excellent. Okay. Mr. Adams?
I've got a few.
Okay. All right.
And then just to be clear, you're seeking to qualify him as an expert in the field of historical cell site analysis. Is that correct?
Don't forget the sub, bro.
Site location information, CSLI.
Okay. Another point of clarity. I noticed that he said earlier in his testimony something about social media. You are not seeking to qualify him as an expert in social media analysis or interpretation.
No.
Okay.
Cell site location information, historical cell site data.
All right. Thank you. Investigator Worrell. Good morning, sir.
Morning.
A couple questions for you. If I heard you
I'll
correctly,
be right back.
I think you said that
I'll be
you
right
get the
back. Y'all
cell
hit this
site
shit.
data
I'll be
information
right
from the
back, bro.
subscribing
Go ahead, watch
company.
this.
Is that
Go ahead.
correct?
Right. Verizon, AT&T, the major network carriers.
Okay. Once you get that information, I think I heard you say that there's a map that is generated of a particular cell phone location based on the cell towers and the cell site locations and so forth. Did I get that right?
Maps of the cell sites that were utilized.
Okay.
Yes.
All right. And so that's my question then, in terms of, do you know what the methodology is that allows for the creation of or the generation of these maps? Is it a computer program or?
Yes. So I could map by hand a CDR. If I took, let's just say, even 2 days worth of data, it would probably take just as many days to map out those records,
Okay.
just based on how many there typically are in a CDR.
Okay.
So a mapping program is there to assist in mapping, as well as kind of a presentation of which cell sites are being used.
So it is something, the generation of a map, because that's where we begin. The generation of a map is something that can be done either by hand, a human, yourself, right? Or it could be done with the assistance of a computer program that assists in generating these maps.
Correct.
Right. So that was my question specifically. If we're talking about a map that is generated by virtue of a computer program, are you familiar with the workings of that computer program, the methodology that that computer program uses?
Well, I mean, I'm not a coder, so what it does behind the machine, no. But when it comes to the mapping, I'm always of the opinion that I should be able to do the exact same thing that machine should do. So I understand what it's pulling from the CDR to map the information.
All right. And so whether you are creating or generating that map simply by virtue of the computer, the computer program, or whether you're doing it with the assistance of the computer, or whether you're doing it yourself, are there noted standards and policies and procedures for how you do that? In other words, are there instructions that this is what you look at, then this is what you do, and then this is how you apply the information? Are there standards, written standards that you reference in doing that?
Well, written standards, each carrier presents their information differently. So there may be a carrier that gives a latitude and longitude of the cell site that's used. So there may be a carrier, Sprint is a good example of a carrier that uses a code showing which cell site is being used. So then we have to actually access a different record from that carrier to decode which cell site is being used. So yes, there are recommendations on how to interpret each carrier's records.
Okay. And so when you're saying, you're using the word recommendations, which I think, correct me if I'm wrong, all right? When you're saying recommendations, you're talking essentially about instructions.
Yes.
Okay. Now, those instructions that would govern the process for evaluating and mapping location, are those recommendations or instructions that are peer-reviewed? In other words, are there different agencies that reviews those instructions and says this is accurate, this is the way that it's supposed to be done, and this is an accurate way of doing it?
Well, it's funny because the carriers also will give instructions on what the meanings are of their records. So in a way, we use the carrier's recommendations and the carrier's instructions to interpret them, not really interpret, but to discern the information that they provide.
Who reviews the carrier's information?
I mean, whoever requests information from the carrier.
Okay. And who reviews the accuracy of the information provided by the carrier?
Whoever requests the information from the carrier.
Okay. That would be you, for example.
Right.
All right. So in terms of, you've got the carrier, the information is then generated and sent to you, right? And you review that information that's been sent to you by the carrier.
Right.
Right. So my question is this. Let's jump above the carrier. Before that information is sent to you, is there an agency, an entity that reviews the accuracy of the information generated and sent to you by that carrier?
I'm going to have to break with this line of questioning. We're disqualifying him in analyzing the call records, not in the accuracy of the records themselves. I think if you'd like to count.
Yeah, they more so go to cross for trial, Mr. Adams. I would concur. I'll sustain the objection.
If I may just respond briefly, Judge, I would suggest to the court that in terms of the accuracy of information that is provided that then later becomes part and parcel of any reports that are generated, I think the testing or the accuracy of that information is relevant and would go towards the overall analysis of whether or not it's been sufficiently peer-reviewed such that it meets the standards for admissibility of his testimony as an expert.
Your Honor, I think what we're just doing here is qualifying the client of CSLI and whether he is qualified to testify about that. I think this is something that would go more to weight.
Yeah, I would concur. I'm going to still sustain the objection.
Yes, sir.
Okay.
I'll move.
All right, go ahead.
All right. You testified a little earlier, Investigator Worrell, about the next step in the process, right, is there being a general location versus a specific location that's determined in the analysis of the data, right? Okay. Now, I don't want to get into the weeds because we're not here to kind of cross-examine the intricacies of it, but you know, for example, that the science tells you that a location can be determined, or a cell tower can give you a location based on the signal coming to it from the device, right?
Right, the communication between the tower and the device.
Right. You also know, of course, that sometimes a signal from a device can bounce off of one tower to another tower when the device is being used. You know that.
Like a handoff?
Yeah.
Yeah.
Yes. Okay. Now, so that brings me then to my question about how you're able to determine the general accuracy of a location. Right? When you look at the cell site data, you generate a map, and you see either a general location, as you described it, right? You see a general location, whether you're able to determine the accuracy. Is there a mechanism for determining the accuracy of that? In other words, can you determine whether or not it actually bounced off of one tower or another tower? Is there a way to test that?
So, in the CDRs themselves, again, depending on the carrier, they will show whether multiple towers were used. AT&T, for example, will show every cell site that one call may have used. So, yes, you can see handoffs there. T-Mobile may show a first and a last cell site, so how the call was originated and how the call was terminated. Typically, they're the same. Sprint, the same. First cell, last cell. So you can see handoffs better with AT&T, but then you will see, like I said, first and last cells with other carriers.
All right. Do you know, if I use the term error rate, you know what I'm talking about? Mm-hmm. All right. Do you know, for example, if there is a way to test what the error rate is of any information that might be provided by the provider that details a location or a tower? Or
Specific error rates, I would say, depend on the carrier. Sprint, for example, to me was a little bit, had a higher error rate. Percentage-wise, I couldn't tell you, but it's all in kind of the evaluation of those records, too. You want to see abnormalities when it comes to cell site information. So if I see that there was several towers in downtown Atlanta, and then 30 seconds later there's a cell site that's used miles away that is physically impossible, that to me shows an error rate with the records. And it can be explained, but as to, I can't give you a percentage of what the error rate would be, but yes.
Would it be fair to say then, and you know, obviously you don't work for the companies, but would it be fair to say that you cannot give us a specific error rate for Sprint versus AT&T versus, I don't know, Verizon might have been enveloped by somebody else? Would that be fair to say that you can't give us a specific error rate for the individual carriers?
A percentage, no, I don't. It's all in how, again, you interpret the records, as well as there are things to account for, too, when it comes to like attenuation of frequency as well. So mirroring and shadowing and objects, the environment exist that affect radio frequency and affect the signal between the device and the tower. So
Which would make it difficult to determine, in this case, a particular error rate of any records that would be provided by the carrier.
Correct.
Okay. Just a few more questions for you. I think I heard you say that this technology and methodology, that's the word I'm going to keep using, is used by other agencies, right?
Correct.
You reference APD, FBI, and some others. Are you aware of whether those particular agencies have any procedures in place for the testing of the accuracy of the information they receive from the carriers?
Well, when it comes to testing the accuracy of the information from the carriers, are you trying to say whether the information was correct when the carriers gave it to the agencies,
That's
or
correct, sir. That's
their
what I'm
interpretation?
That's what I'm asking.
When it comes to whether, this voice call was accurate in its time or date, I don't know. But when it comes to the interpretation of the cell site information, so determining a general area, they can perform drive tests and determine what the strength of a particular tower may be.
Okay. Do you know, though, whether or not the agencies that you've referenced, for example, APD, FBI, the others that you're familiar with that have quote, used this technology, whether they do in fact have procedures in place for the testing of the accuracy of the information received?
I think this is asked and answered. I think you just asked.
Yeah, it's asked and answered. I'll sustain the objection.
All right. I didn't get the answer. I guess the answer is they have it in place, but you don't know how often they use it or anything.
Correct.
All right. You were asked in regards to the records that you took a look at. We're talking about in a case involving a gentleman by the name of Javon Fleetwood.
Correct.
Do you know what agency, what carrier was involved in that particular case analysis?
I do not recall if it was T-Mobile or Sprint.
All right.
There were several records that we obtained from that case. One was definitely T-Mobile, but again, Mr. Fleetwood's, I don't recall.
All right.
I can refer to my report, I could tell you, but
Do you have your report anywhere in front of you?
I do not.
All right. That's right. That's all I've got. Thank you.
Okay. Anybody else? Mr. Jimenez, go ahead, sir.
Good morning, Your Honor. Good morning, State.
Morning, sir.
Sudi Chalak, Jimenez, on behalf of Mr. Dorsey. How are you, sir? Good morning.
Good, how are you?
Good. All right. I want to just have a few questions. Now, you say you received these data from the cell phone carriers. Is that right?
Correct.
And this data was created. This is kind of like, it's a data dump. It's just metadata they give you. They give you everything. Is that correct?
I wouldn't say everything, but, the date and time of the call, who the call party was, how long the call lasted, again, the cell site, the sector of the cell site. So, yes.
And when you say cell site, the reality is that there are millions of cell towers throughout the United States, is that right?
There are quite a few.
And the phone company doesn't own any particular cell tower, is that right?
Own, I mean, they may contract out for property, but maybe I'm not understanding.
Let me rephrase. One cell tower could actually share and be used by multiple.
Absolutely. Yes.
And then so whoever controls that data then gives it to the cell tower, again, then gives it to the phone companies, is that right?
Well, no, the phone companies they have a retention in place where they also service the antennas that are attached to these cell sites. So, I mean, this is just records. I don't know the intricacies when it comes to who gives who the records inside that company. I don't know how to answer that.
But you said during direct that whatever records they do have, they collect them for their own use.
Right, right.
For example, they collect it for billings purposes.
Right. Also,
Object to that line of questioning. I don't think he can testify why phone companies collect records. He's not a phone company expert.
I think he just answered it. He does know. If he knows, he can answer it. If he doesn't know, he can say, I don't know.
Okay, well, can you answer that, Mr. Worrell?
the records initially, when I would say there are many factors when it comes to why the records were kept by the carriers, one of which was originally billing when like I said, when we would have a limit on minutes or texts or things like that, but as well as they use these to know if their product is also working. So they determine whether there's a dropped call and kind of just the status. This is just in-house records that they keep. This wasn't developed to track or do anything like that.
Selesky, it was not developed to track their clients. Is that right?
I don't know when it comes to their intentions. I would say that because of the nature of the records themselves, it shows location information. I don't know the conversation that a carrier would have in regards to like why we're keeping these records. But I would say when it pertains to law enforcement, they don't retain these records so that they can just give them to law enforcement for law enforcement to track. What they do with their records is their business. But we know that they exist, and so we request them when it's necessary.
So let me pivot a little bit from what you just said right now. Law enforcement gets these records for them because you know they exist. Is that right?
Correct.
And to get them, you actually have to either subpoena or get a warrant.
With cell site location information and search warrant, yes.
Okay. So they don't just freely give it to you. There's actually a process.
Correct.
Now, you've received quite a bit of training. Is that right?
Yes.
You listed a number of years, thousands of hours that you received in training, specifically as to cell tower locations.
I would say my total number of training is close to 2,000. I wouldn't say that's all dedicated towards this type of technology.
And is it fair to say that all the training related to this type of technology has been given to you by either a law enforcement agency, the FBI, or some other company that is in the process of helping law enforcement? Is that right?
A company, they'll help law enforcement. They'll help, I think, anyone that requests their help. I don't know who their clients are, but could be.
But have you ever gotten training by Verizon?
No.
Have you ever gotten training by Sprint?
No.
Have you ever gotten training by T-Mobile?
No.
So the actual phone companies, the ones that have these records, have never trained you on how to use it?
Correct.
All right. All the programs that you mentioned, these are third-party private companies, is that right?
Correct.
They are not the phone providers.
Correct.
And what they do is they take this metadata and then they make it pretty into a map. Is that right?
They will, yes, map the data.
So it makes your job easier. You know how to do that.
Correct.
You can look at one location, you can look at a second and a third, and then you triangulate where that actual phone may be.
No, I don't do it in regards to you seeing multiple cell sites that were used by the device, I don't triangulate. I show the cell sites, and then you will see, I will map the neighboring cell sites for that carrier. When, I don't triangulate.
Okay. So how do you,
That's getting more specific. That's actually trying to show a specific location.
do you know how to do that?
No,
Okay.
that's not what's done with CDRs.
Okay. Now, you are aware that there are apps, there are softwares that can emulate another phone number, is that right?
Correct.
And then you're only going for the phone number, you're not actually looking for the device, is that right?
For CDRs with CSOI is the phone number, yes.
So if somebody's emulating,
I'm going to object to this line of questioning. We're just asking if the science itself is reliable.
Yeah, I mean, this is all cross-examination, Mr. Jimenez.
yes, you are, and if I may respond, when
It goes to weight. It doesn't go to the criteria of admissibility of the science itself. That's the only thing that, this is a threshold under Daubert I got to decide, so.
absolutely, it definitely goes to weight, and we will challenge that at trial. However, this is the gatekeeping phase to make sure we're not getting any junk science in here. I mean, it is, just because law enforcement has used it for thousands of times doesn't mean that it is good science. As not counsel for Mr. Williams was asking, there is error rates. There are issues with this data. And it is not data that they're creating. It is not even data that is peer-reviewed. It's just billing information, which I would argue to the court, it was never created to track their customers. And they are just looking at numbers, looking at metadata, and getting whatever they want out of it.
Okay, anything else, sir?
Nothing.
Okay, all right, thank you, sir.
Thank you.
Okay, all right, anybody else? All right, Mr., you got to identify yourself for the record.
Yes, Your Honor. Attorney Eric Johnson for Mr. Eppinger.
Thank you, sir.
Thank you. Good morning, sir.
Morning.
Based on the testimony that you gave earlier, you said that you receive information, data regarding the location of the cell phone, correct?
Location of the cell site.
Okay, location of the cell site. And as it relates to the actual phone itself, you said that you can't pinpoint the exact location, but a general location, correct?
Correct.
And what is the range of that location as far as how wide a net is that?
It just depends on the area. It depends on the neighboring cell sites. Each cell site may it could be within a mile, depending on the area. I couldn't tell you that one particular cell site has a range of 1.2 miles. I don't know that.
Based on your experience and all the testing that you have done, what would you say is the average range that you've seen throughout your career as far as the difference between actual location and estimated location?
So, again, it's difficult to say because in an urban area, you're going to have a much more concentrated field of cell sites. In a rural area, it's much more sparse. So I couldn't give you an average range.
Okay. But you will say that it's much more difficult to obtain an exact location in the urban area than it would be in a rural area.
No, I wouldn't say an exact. It's difficult to determine an exact location. We don't determine exact locations, but I would say that it's actually more condensed range in an urban area because of the concentration of cell sites. I could show you a map, and you could visually see the thousands of cell sites within the city of Atlanta, and then as we grow further away from the urban area, you will see a less dense population of cell sites. And there's a reason because of the volume of clients. I mean, here you're going to have much more use of the cell sites, and they need to maintain the coverage, and they need to maintain keeping their clients.
Okay. And I believe you testified that in this particular matter, you analyzed the phone for Mr. Fleetwood, correct?
Correct.
And that information was given to you by the state as to who the owner of who the phone was attributed to, correct?
No.
Okay, what did you get?
So I determined who used that phone through my investigation.
Okay. And so based on the information that you receive from the cell phone carrier, it gives you the specific individual who made each and every call?
No, I mean, it gives us subscriber information, but attributing the number is more than just looking at the records, more than just what the carrier provides as well.
So how did you, what steps did you take to say that this was Mr. Fleetwood's phone?
Well, during the incident, there was a cell phone that was abandoned near one of the vehicles that was used in the shooting. That phone had multiple numbers attached to it, as well as conversations. I don't remember the specifics off the top of my head, but conversations that led me to believe that one user of a particular phone number was involved in the incident. That number, I searched through Securus, our jail call information, and identified individuals based on that.
However, but nothing could tell you exactly who made the text messages that were given.
Your Honor, I'm not against this, the same objection.
I stand the objection. That's trial-related cross-examination. Perfectly fine at that point in time, Mr. Johnson.
I'll move on, Your Honor.
Okay, all right.
So outside of actual location, as far as the general location that is given, what other specific or specialized information do you provide in your analysis as a cell phone locator?
Not quite understanding the question.
What I'm saying is you are here today to be attempting to be qualified as a cell phone location expert. So
No, cell detail records, cell site recognition information.
cell site recognition. So, and I guess I don't really understand what that means. What exactly does a cell site recognition expert mean?
Your Honor, we're trying to qualify an expert in historical cell location data and cell site location information.
Okay.
Cell site information what?
This is cell site location information. It's called CSLI. Is that?
CSLI, okay, and then what else was the other one?
Historical cell.
So it's, yeah,
Hold on, sir, hold on. Historical what?
Cell data analysis.
historical call detail records with cell site location information.
Okay.
Analysis.
So, does the information that you receive as far as the cell phone locations tell you exactly what person is in possession of the phone at the time?
No.
And as far as the locations that are given, these are things that come up. I believe you mentioned you can pull it up on Google Maps and see these locations.
Once the information is digested and a map of some sort is presented, yeah, you could use Google Earth, but...
Okay. So if given this information, anybody could map these things out, correct?
With a program, yes.
Well, aren't the subscribers themselves afforded? Can't they request the cell phone data information on their account from the subscribers?
No. I mean, they can request their phone records, but it won't come with cell site information.
So this information...
I mean, I've tried to do it, and I could not do it.
So this information is something that is only provided to law enforcement?
I believe, I don't know if maybe as a private citizen I could go through the hoops of trying to get that. I don't know. I couldn't answer that.
And the program that you use to analyze this data, where did you get that program from?
So I've used several different programs. Hawk Analytics provided one program called CellHawk. I've used a program that the FBI has provided, so I've used a couple.
So are these programs available to the general public, or is it just something for law enforcement?
I don't know who they're available to.
In your experience, have you ever known anyone in the general public to use these programs?
I don't know.
So it's safe to say that all of your knowledge and involvement with these programs come from your involvement with law enforcement?
Yes.
No further questions, Your Honor.
All right. All right, having no other cross-examination. Matt, anything else?
Your Honor, if the court would like to have case law, I have that available.
I'm good. I'm good. Based upon the testimony of Mr. Worrell, I'm going to designate him an expert as a CSLI and historical cell data and cell site information data expert.
Your Honor, let me pose an objection if I can. For the record, I understand the court's ruling, but I need to put on the record my objection to him being qualified in the manner as stated. I'll be succinct, and there are 4 specific objections that I have to indicate that he does not meet, this particular individual does not meet the Daubert and 702 standards.
How? Specifically.
I'm about to get to it.
Okay, let's do it.
All right. Succinctly, 4 things. Number 1, he has testified in regards to information that's provided by cell phone carriers, but he has not testified that there are any publications in support of the methodology that is used for the gathering of that information, nor has he testified in regards to any publications that are in support of the methodology used for evaluating the accuracy of that information.
Not required.
That's fine. I disagree, but that's my first objection.
Okay.
Number 2, he has testified that generally he believes that these methods are generally accepted. I believe his testimony was in the field of policing. There's not been any testimony, and used by other agencies. There's not been any testimony that any of these agencies that have been used, either APD, FBI, or the one cited, has any processes or procedures in place for the testing of the accuracy of that information. I believe that he has
They can drive by. Agencies can drive their information. So that's a way of testing it. What else?
Yes. He testified that he is not familiar with what the error rate is for the information that is provided. I believe his testimony was that different companies have different error rates, but he is unaware of what the error rate for the information gathered and transmitted is. And finally, there's been no testimony that there's any peer review of either the analysis done by this particular individual or any peer review of the information that is provided by any of the carriers. I believe for those 4 reasons that it fails to meet the standards set in Daubert and in 702, and I would ask that he not be qualified as an expert in the field proffered.
Okay, Ms. Rosenwasser, you want to respond to that, please? And then I'll let Mr. Johnson then go ahead. Mr. Johnson, go ahead, and then I'll let Ms. Rosenwasser respond to everything. So, anything else? Remember, everybody gets the same thing, okay? So do you have anything else you want to tell me?
I know.
That Mr. Harvey took care of that for you?
I got you, Your Honor.
Okay, so is there any other base other than those 4 that have been mentioned already?
Yes, Your Honor.
Okay, all right, let's just don't replicate the
I understand.
4 that Mr. Adams has eloquently presented for us already.
Your Honor, and we believe in this particular matter, Eric Johnson on behalf of Mr. Eppinger, that this individual lacks the that the information that he will be testifying to is not specific, technical, or specialized in such a way that it would assist the trier of fact in this matter. He has testified that he will be given information regarding cell phone location information.
Okay.
We believe that would be improper in this particular matter, Your Honor, because effectively, the cell phones are not on trial in this case.
But location of individuals who may possess identifying data associated with that phone, I mean, it's only as good as, I mean, the jury can decide not to, of course, consider it as evidence. They can consider the weight thereof. But, you know, there are various reasons that cell phone data is offered for a trier of facts consideration. Yeah.
Well, Your Honor, what I would say is, ask him specifically, does the information that he received tell you who is in possession of the cell phone?
No, but what it does do is, if you associate that phone with certain information, the jury can make an assumption, if they choose to do so, remember, they don't have to,
I understand, Your Honor.
that particular individual may have been in this particular area, or that particular individual's phone may have been within this particular area. So that's helpful to try our fact.
I think that's a separate issue, Your Honor, because he's not testifying to the content of any
He's testifying to the science of whether or not the record, not the record, I should say, because the record is given from the phone company.
Right.
They get it by warrant or other permission.
Understood.
And then they go ahead and they extrapolate and present this data in terms of, for the reasons they say. It's offered for whatever the jury views it as.
Well, Your
in terms of
Honor,
that.
in this particular matter, if we look at it specifically as to what he was qualified for as it relates to location, in this particular matter, we're not speaking about what else the content on the telephones may be. As it relates to this particular location in this case, he has testified that he does not get a specific location, only a general location. He cannot even give the estimation as far as what the amount of error is in that estimation. So therefore, he cannot tell you specifically where the phone was, nor can he tell you specifically who was in possession of the phone. So effectively, Your Honor, they're using his status as an expert to bolster the testimony that he knows himself is speculative in nature.
All right, okay. Anything else?
No, Your Honor.
All right, Ms. Rosenwasser, anybody else? Ms. Rosenwasser, go ahead and respond to those four and Mr. Johnson's issues with the that he's just raised.
Your Honor, it's our contention that this is an appropriate field for this individual to be qualified under Jobert. He has testified that this field is recognized. It's something that's done by the FBI, that this is done by many police departments in this state. And the fact that, Your Honor, that this is not a situation, we're not asking, he's not an expert whose phone it is. That goes to weight, not admissibility. That was my original objection to that questioning. And, Your Honor, I think that I would just, to answer all these questions, I'd like to point the court to United States versus Jackson. It's a 2017 decision out of the United States District Court of the Northern District of Georgia, which is us.
What's the site on Jackson?
That's 2017 U.S. District Court, and it's on Lexus 221421, and that's a 2017 United States District Court case. In that case, the court found that an expert, just like Investigator Worrell, was qualified to offer this because the CV in his testimony established that he has extensive education, training, and education in the fields of telecommunications and historical cell site analysis, and he has a lengthy history of testifying in court proceedings. Additionally, what is important that I'd like to point this court to is that the Northern District Court found that this is a reliable methodology, which is what the question is here. Is this a reliable methodology? The court found courts from around the country, including other judges in this district, have found that similar testimony to be based on reliable methods, and it cites to several cases that I can provide the court with right now. It cites to a case called U.S. v. Foster, F-O-S-T-E-R. That's another Northern District Court case, Lexus 89791. United States versus Lewisby, L-E-W-I-S-B-Y, 843 F3D 653, 7th Circuit 2016. United States versus Frazier out of the District Court of Nevada in 2016. U.S. District Court Lexus 126479. United States versus Johnson out of the Northern District of California. United States District Lexus Site 111921. Again, 2015, and United States versus Jones, 918 F sub 2D 1 out of the District Court of the District of Columbia in 2015. And so then the court in Jackson goes on to say, defendant's challenge lies in the assumptions that the agent might make into question the accuracy or reliability of his opinions concerning the locations of phone. But these assumptions go to the weight of the agent's testimony rather than to its admissibility, which defense counsel can go into on cross-examination. Additionally, should the court like to hear cases from other circuits, I have those. I think it's important in Rule 702. The Georgia legislature said that it's the intent of the legislature to draw from the opinions of the United States Supreme Court and other cases in federal court. It doesn't limit us just to the 11th Circuit. So I will point the court to United States versus Lewisby, which is the 7th Circuit case that was cited in Jackson. That case said using call records and cell towers to determine the general location of a phone at specific times is a well-accepted, reliable methodology. The court also found that the expert in that case was qualified with 350 hours of training in the systems used to do this. And we heard here that Investigator Worrell actually has a lot more training than that, so he's certainly qualified. Additionally, the court in that case notably said that this is not going to be something where he says this is an exact location. Investigator Worrell explained that it's not an exact location. That's the same thing. Your Honor, In United States versus Adame, A-D-A-M-E, the Seventh Circuit in 2016, the Seventh Circuit just specifically said that this is a reliable science. The court found we recently explained the admissibility of historical cell site analysis under Federal Rule 702. We noted that historical cell site analysis can show with sufficient reliability that a phone was in a general area, especially in a well-populated one. It shows the cell sites with which the person's cell phone was connected, and the science is well understood. Your Honor, the Fourth Circuit similarly admitted this in United States versus McNeil, 763 Fed APPX 307. That's the Fourth Circuit, 2019. The court found that the district court did not abuse its discretion in concluding that the cell site location evidence satisfied Daubert's touchstones of relevance and reliability. The court also found historical cell site analysis has been broadly tested and accepted by the scientific community and the federal courts alike. Additionally, in United States versus Jones, that was the case I cited earlier, that was cited in Jackson. The District Court of the District of Columbia Circuit found that on the whole, the court is persuaded that the expert's proposed testimony is based on reliable methodology. Indeed, the use of cell phone location records to determine the general location of a cell phone has been widely accepted by numerous federal courts, and it cites to United States versus Schaeffer, SCHAFFER 439, Fed APPX 344, Fifth Circuit 2011, as well as district court cases from the Eastern District of New York and the Northern District of Illinois, namely United States versus Dean and United States versus FAMA, F-A-M-A. Similar to the arguments that I've been putting before this court, the district court circuit in Jones explained that to the extent that Agent Eicher's testimony relies on assumptions about the strength of a signal given from a given cell tower, any challenges to those assumptions go to the weight of his testimony, not its reliability. Indeed, numerous other courts have concluded that the mere existence of factors affecting cell signal strength that the expert may not have taken into account goes to the weight of the expert's testimony and is properly the subject of cross-examination, but does not render the fundamental methodology of cell site analysis unreliable. So, Your Honor, we would ask that this court qualify Investigator Worrell as an expert.
All right, I am good. Yes.
Before the court makes the ruling, I would like to make my argument first, please.
I gave everyone an opportunity, Mr. Hoover.
When I stood up and raised my hand, you went to Mr. Roosevelt.
You didn't.
I just, for the record, it'll be quick, it'll be simple, but I have to make the record clear.
Are you going to make any other objection that hasn't been made already?
I'm going to clarify.
Are the five or six areas that we've gone through already?
I want to clarify what my esteemed colleagues have said. Yes, for the record, I want to clarify because I see where this is going, and moving forward, not only with this expert, but the experts we've already dealt with and the experts moving forward, I just want to clarify the record of what.
All right, well, go ahead. Go ahead.
Your Honor, the issue that I have is there are two different ways, because you're the gatekeeper, that you need to look at this. Number one is the validity of the methodology. We're not arguing that at all. Validity is applied is the issue that we all have. And all I'm saying is this witness simply said he's testified this many times, he's done this for this many years, and that makes him an expert. We're not arguing that the methodology itself has a problem.
We back.
The way he applies it is. Your Honor, in my 10 years of being a defense attorney, I've never gone to trial with the client and that client be convicted of a murder.
All right, we back, bro.
Because I've done it for 10 years, does that make me an expert in murder trials? No. What we're talking about is this witness simply says he can't tell you what these cell sites are doing. He can't tell you what the cell companies are doing. All he does, he gets the information and he interprets it. Just because he's done it for however many years or how many times.
Yo, I'm ready to probably get on Monkey too before I get off. What the fuck?
What does strength mean to you? Some say it's how fast you run a mile, but there are other.
The state doesn't concede that, but the fact of the matter is, it walks directly into the elephant in the room, which neither motion addresses in any way, which is the presence of count one, the RICO conspiracy count. There was no mention of that count in any of the arguments. It was simply not addressed, as though if it were ignored, it would somehow go away. Not one case cited by counsel for either movant is a RICO case.
Well, you're really sleeping for real.
And so why does RICO change this? Well, it changes it for several reasons, but the first of which deals with the definition
I need to do a few
of racketeering
things.
activity. Because when, and I've made the point previously that a pattern is not an essential element of the conspiracy claim. But that doesn't mean it isn't relevant at all. That doesn't mean the state can't introduce
Give me 1 second, y'all.
evidence
I
of
gotta
it,
do a few things on the computer
because
real quick.
the actual commission of racketeering activity supports the inference of an agreement to engage in that activity. And the granddaddy case on that is United States versus Elliott, 571 F. 2nd, 880, a 1978 former Fifth Circuit case, which has subsequently, of course, when the 5th and the 11th separated, when the 11th was created, that law became the 11th Circuit's law. The 11th Circuit has reaffirmed Elliott many times. So this evidence is relevant. And when you look at 1614.3, the definition section of RICO, subpart 4A, the definition of a pattern of racketeering activity. It says engaging in at least 2 acts of racketeering activity.
I think I'm ready going monkey for my last little, you know what I'm
schemes or
saying?
transactions that have the same or similar intents, results, accomplices, victims, or methods of commission, or otherwise are interrelated by distinguishing characteristics. In other words, that is exactly.
We gained another sub, bro. Thanks for the sub, bro.
The movants are relying
Keep
on
subbing.
for severance. Here, every defendant is alleged to be an associate of YSL.
I have a video dropping.
When we look at
I know y'all here for the trial, but I got a video dropping.
At the attempted murders,
So,
which were not mentioned in the severance.
What I'm gonna do
motion,
is
by Mr.
I
Stillwell.
gotta,
Every victim
what's the name, man?
in the
This
murders
video's long overdue,
that are
bro.
relevant to one or both of these movants was an associate of a rival gang. And so,
I'm dropping this at 1 o'clock.
just saying these acts are unrelated doesn't make it so for the
Today,
movants.
30th?
We have gang associates, killing gang associates, trying to
Yo,
kill
I'm
gang
dead serious ready
associates.
going monkey, bro.
We have them getting arrested
Ready to
shortly
get
after
jumping real
murders and
quick.
attempted murders
Like 9
with
o'clock in the
weapons in their
morning.
possession.
Ooh,
And the charges
1:30.
are possession of a firearm by a convicted felon who was previously convicted of a felony involving use or possession of a firearm. In this case, counts 64 and 65, 3 days after the murder of Shamel Dirms. So these are not unrelated. They go to the question of association with the enterprise. They go to the question of knowledge of the enterprise's activities. And in each case, each of these murders and each of these attempted murders, and the count 64 and 65, the individuals we're talking about were present with other members, other associates, of YSL. None of these are one-on-one murders. None of these attempted murders are one-on-one.
Wait, Derek back.
And the arrests in possession,
I probably gotta wait for y'all.
Mr. Nichols and Mr. Stillwell are together at the time.
Lock 'em up.
That is exactly what RICO says is related, and that achieves that was designed specifically to prevent this kind of severance, where acts committed in connection with association with the RICO enterprise by persons associated with it do not get chopped up, do not get severed. And when I say chopped up, I'm not kidding. I had a little trouble counting, and if I'm wrong, I apologize. But although the math is the exact method of severance and reason for severance is not identical between Mr. Nichols and Mr. Stillwell, if you were to grant their motions as written, they would have 4
but
trials.
go to sleep at night, boy.
Each.
But playing Call of Duty, that's why I be really
Because
arguing.
none of them says the RICO trial doesn't go forward. And none of them says the overt acts we're talking about that are also some of these counts don't come into that RICO trial. So the jury is going to hear that evidence, even if you sever out a murder charge, even if you sever out a gun charge. still going to be heard as part of the conspiracy charge. So
Yo.
all the
Video's private,
inefficiencies, but
I don't like
none
this
of the
court case.
supposed protections.
We ready to get, we ready to get lit real quick, bro.
You know,
I don't know what it
So
says.
stay in the
they can't
chat.
create a
Ready to get
vacuum
lit.
in which
Real
count
quick.
one doesn't exist.
We need loud people.
And they
like,
can't create a
not-
vacuum
he's
in which
lame.
count one and RICO don't serve the purpose they were specifically designed to serve. And I recognize that that may present additional difficulties for the defense. But that was the General
we need
Assembly's
a Shirley
decision.
bag, bro.
And all the due process arguments that you've heard today have been made in reference to RICO. They have all failed. You've heard a number of due process arguments already in various contexts. But the fact of the matter is, Georgia RICO and federal RICO have survived every due process argument ever made against them. And that includes arguments arising out of severance motions. Again, the answer to this is RICO, and neither Mr. Stilwell nor Mr. Nichols have cited a RICO case, have cited a RICO provision, have sought
I ain't
to
gonna even
distinguish
lie, bro.
any of the grounds that apply here,
Let me
or have sought to
let me
address any
see.
of the hundreds of cases that have rejected
Let me see
exactly
what.
the kinds of arguments
Oh
we're
yeah, let me
talking about
copy
here.
this.
The idea
Video
that
dropping
murders
today.
happened on different dates, have different victims. Well, murders usually do have different victims
Video
if they
dropping
occur on
today.
different dates. But that doesn't change anything here.
Let me see if I can get my thumbnail phone.
I'm on PC,
argument.
so
Because part of what it is designed to address
Hold
is
on,
people who
let
commit
me-
multiple crimes over an extended period of time. That does not strengthen a severance argument. It actually weakens it.
that boy sleep. That boy Thug sleep.
The argument that what the state is really using is a propensity argument, I take it that's meant to be 404B, gun toting, again,
610.
doesn't address the nature of the RICO pattern definition. If there is one of the organizing principles that RICO talks about, and those include the same or similar victims, we have that here. Every murder victim, every attempted murder victim, as to these two defendants, the counts we're talking about, is an
I
associate
guess
of
we
a
can
rival
watch
gang.
this, bro.
Same or similar intents. Kill members of associates of rival gangs. Same or similar results. They are killed or they are wounded and survive. Same methodology. Firearms are used. Not talking, none of the rival gang members are attacked in any method other than, outside of a jail, other than using a firearm.
Where's the like button? With the
And
thumbs up.
while it may be a propensity, we have the fact, one of the ways, if you want to show that you're a member of an enterprise, is you have a person who's
Yeah, I'm gonna keep it a
got a gun
stat, bro.
conviction, and the first thing they do when they get out is they acquire a gun, and they commit another crime. That is consistent with the concept of enterprise, not antithetical to it.
What's up, Andre?
I can go on, but I think if the court has any questions for me to address, I'd be happy to do so. But the overriding principle here, I think, is this, Your Honor. Even if you
Yo, I'm gonna keep it a
separate out
stat.
the counts they're talking about, all the evidence comes in the main conspiracy trial. They haven't given you a reason why any of the
Yo,
counts-
listen. It's 7 of y'all in here, bro. We ready to get lit real quick, bro. We ready to have a little bit of fun before I end. Let's get on. Oh, wait. I think I'm banned on that one. Hold on. Fuck. It may not work. It may not work. It may not work. Hold on. It may not work. I got too much shit open. It may not work. So in the meantime, y'all can watch this. In the meantime, while I figure this out. My fault. I had it on mute.
I'm ready to snitch. 'Cause I'm snitching on you. Nino, you're the first person I'm snitching on.
Judge, can I have a response?
Back to the
brief
stream call,
response
bro.
here?
Oh my gosh.
Okay, Mr. Harvey.
Judge, I think Mr. Floyd, while a very smart man, is a little bit disingenuous in his argument. I heard nothing, not a single thing related to how count 65 is admissible in count 1. Not a single thing. All he said was, yo, Judge, RICO, everything comes in. Wrong. That is absolutely not true. Number one, this is an indictment.
We ready to do something funny for like 5 minutes, bro.
The March events. And indeed, it was superseded on August 5th, 2022. That was well after the alleged March 17th event in count 65.
Nah, it's just today, like today, like this case. It's not here.
191 predicate.
Hold on, Chad, I'll be right back.
Count 1. Count 65 is not one of them. If the state wanted to say this was part of the RICO conspiracy, they could have put it in as a predicate act. They didn't put it in as a predicate act. They didn't mention anything in count 65 that this was related to either RICO or a gang prosecution. So when we say, when Mr. Floyd says you can't take this in a vacuum, they indicted it as a separate standalone offense unrelated to the RICO enterprise, and I've heard nothing that suggested it's otherwise admissible. It hasn't been noticed under 404B. It hasn't been put in as a predicate act in the RICO conspiracy. It was indicted as a separate standalone count. And you can take nothing else. I've heard nothing else to suggest that it
Bro, we ready to get, bro. Let's ready to do real quick, bro.
It's admissible in the RICO conspiracy. So it is not.
I don't know if this gonna work though.
It is not part on the indictment's face. It is not part of the conspiracy that's charged. Saying it's relevant doesn't make it relevant. In fact, the cases say just the opposite. It's relevant in 403, prejudicial as a standalone count, nor has it been indicted under or noticed as 404B. So I would suggest to the court that it is a standalone count. It should be severed. And again, I have a different argument than Mr. Sharp has on his double murder. But as far as count 65 is concerned, that should be severed. It is very easy to try the underlying case without anything to do with count 65. The underlying case can go forward without anything coming in from count 65. And it's nothing to sever as the court should count 65. So I'll leave it there.
Thank you, Mr. Harvey.
And Your Honor, briefly, may I?
Just because you said may I, go ahead.
Thank you, Judge. I adopt Mr. Harvey's arguments regarding my client.
We got 9 people. Shout out to the 9 people that's in here, bro. We ready to try to do something funny, bro.
I agree with him wholeheartedly. I would just also like to point out that Attorney Floyd, pointed out to the court that part of this is Mr. Stillwell and Mr. Nichols were associating with each other on March 3rd. They can still say that, but it's the presence of the gun that is wholly irrelevant and deserving of its own separate trial.
Actually, Mr. Short, if I did do that, I could just sever the count. If I was more apt to do it, I'd just sever the count, let that same jury go ahead and pass on that issue. If your client were
making it happen since 1889.
We're gonna watch a new case here, bro. This is the newest case. Why I figure out so I say we'll go right here.
and they commit another crime.
Let me change the title.
That is consistent with the concept of enterprise, not antithetical to it. I can go on, but I think if the court has any questions for me to address, I'd be happy to do so. But the overriding principle here, I think, is this, Your Honor. Even if you severed out the counts they're talking about, all the evidence comes in the main conspiracy trial. They haven't given you a reason why any of it doesn't, which makes severance pointless. All the inefficiencies, all the problems I've talked to you about in earlier arguments apply. You simply end up with a series of complicated trials. The severed ones for these defendants might be somewhat simpler. They might not involve all of the evidence in count as would be in a trial in count one. I don't want to misrepresent there. But there would still be a ton of evidence that comes in for context and other reasons. They would not be simple trials. And therefore, the motions for severance should be denied.
Okay.
Judge, can I have a response, a brief response here?
Okay, Mr. Harvey.
Judge, I think Mr. Floyd, while a very smart man, is a little bit disingenuous in his argument.
All right, we got a new title.
Nothing,
for
not a single thing related to how count 65 is admissible in count one. Not a single thing. All he said was, yo, Judge, Rico.
All right, let me do this.
Wrong.
I'm ready to get on monkey for like 30, like,
not
for a little bit.
Number
Let me see
one,
that shit.
this is an indictment that came down after the March events, and indeed it was superseded on August
I ain't even streaming for an hour.
2022.
Right.
That
Let me
was
see.
well after the alleged March 17th event in count 65. I will note that while there are, 191 predicate acts in count one, count 65 is not one of them. If the state wanted to say this was part of the RICO conspiracy, they could have put it in as a predicate act. They didn't put it in as a predicate act. They didn't mention anything in count 65 that this was related to either RICO or a gang prosecution. So when we say, when Mr. Floyd says you can't take this in a vacuum, they indicted it as a separate, standalone offense unrelated to the RICO enterprise, and I've heard nothing that suggested it's otherwise admissible. It hasn't been noticed under 404B. It hasn't been put in as a predicate act in the RICO conspiracy. It was indicted as a separate, standalone count. And you can take nothing else. I've heard nothing else to suggest that it is just because it's indicted, it's admissible in the RICO conspiracy. So it is not part on the indictment's face. It is not part of the conspiracy that's charged. Saying it's relevant doesn't make it relevant. In fact, the cases say just the opposite. It's relevant in 403, prejudicial as a standalone count.
6 people in here, bro. Appreciate y'all.
Been indicted under or noticed as 404B. So I would suggest to the court that it is a standalone count. It should be severed. And again, I have a different argument than Mr. Sharp has on his double murder. But as far as count 65 is concerned, that should be severed. It is very easy to try the underlying case without anything to do with count 65. The underlying
I'm
case
trying to laugh, bro.
Without anything coming in from count 65.
I'm trying to laugh real quick before I end.
It's nothing to sever as the court should count 65. So I'll leave it there.
Thank you, Mr. Harvey.
And Your Honor, briefly, may I?
Just because you said may I, go ahead.
Thank you, Judge.
Then what we gonna do is
Mr. Harvey's arguments regarding my client, Mr. Stillwell, on count 64, and I agree with him wholeheartedly. I would just also like to point out that Attorney Floyd,
cool.
you know, pointed out to the court that part of this.
All right,
is
chat. We got 8 people in here, bro. I'm ready.
I'm
ready to try to go on Monkey and see if somebody can make me laugh. They make me laugh. I'll cash out.
On March 17th. I don't want to speak for Mr. Harvey.
I
am not arguing that they can't say that they were arrested on March 17th.
Hopefully I don't get,
and they were
what's the name?
together. They can still say
Hopefully
that.
I don't get
but
banned.
it's the presence
But
of the
what I'm gonna do
gun
is I'm just gonna
that
go
is
back and forth
wholly
because I don't want
irrelevant
nobody
and,
to put
deserving
TOS.
of its own separate trial.
Up with this,
Actually, Mr. Short, if I did do that, I could just sever the count. If I was more apt to do it, I'd just sever the count, let that same jury go ahead and pass on that issue. If your client were found not guilty, of course we'd have another trial. But if your client's found guilty, I'll let the jury go ahead and just handle that one.
Yo, how many of y'all snitching, bro? Keep it 100.
Well, are you suggesting a bifurcation?
Yeah.
How many of y'all snitching,
no,
bro?
I that's not what I'm asking for. And this is why, because it goes back to I care about this gun charge as well. So this gun charge is a standalone count, and I don't really want this jury, after being exposed to evidence, even after they acquit my client of 2 murders.
I'm doing something on the computer real quick, so hold on. I gotta turn my camera up here.
Guilt or innocence
He's not gonna let me do it over there. So hold on.
Gun charge. So I think it needs to be removed from the indictment wholly, and that would need to be tried. But Judge, the good news is, as Chief Judge, you could send it to someone else, and we could deal with that another time. But in just turning the page briefly,
wait, hold on.
Regarding my arguments about the double murder, you know, I understand Mr. Floyd's point, but Your Honor, I still, it's all based on.
No, appreciate the 8 people that's still in here, bro.
And so therefore it makes it okay. And I just reject the premise and the argument that the state always just gets to set the procedural rules. All right, cool. And the state, just because they choose to indict somebody a certain way, my client must accept the fact that he's...
All right, listen.
The 2 cases
I'm live on
against
YouTube right now. Can y'all do something to make me laugh, bro? Like, I'm live right now. Like, tell me a joke, bro.
Huh?
Tell me a joke or something. Like, I'm trying to laugh. I'm on YouTube live right now. I'm live. Yo is wilding on him.
His granddad got put in a pack.
Hey, yo, all right, keep it a stack, bro. Keep it a stack. So, is he allowed to say? Do you give him the N-word pass or no?
Whoa. We're on YouTube. We're fucking famous.
Yo, y'all kind of funny.
Made you laugh.
We made you laugh.
We made you laugh.
Hey, yo, y'all got it. Yo, wildin'. Bro, I'm trying to...
स्विच ऑफ कहाँ बा हमारा मोबाइल
Yo, it's all freaks on here, bro. Like, these freaky ass men. Yo, playing a game and shit. My camera looks so good on Omegle, bro. Nope, not doing it. Should I try going monkey now? Chat, should I try going monkey? But my camera ass on monkey though. Like, my shit is ass. Let me go on monkey real quick. We're gonna leave this site. We're gonna try it real quick. If it's dry, bro, we can watch the rest of this, bro. If it's dry, we can watch the rest of this. If it's dry, we can watch the rest of this, bro. If you still in here, bro, make sure you share the live. Drop your cash tag. Oh, shit is working. Oh, shit is working. What's up? Why is it not working? Oh, wait. What the fuck? Where did it go? Come on, this shit bugging. This shit is bugging. Why my camera not coming up? Bro, we can just watch this, bro, at this point.
Other than his geographic proximity at around the time of the murder, according to the state, according to the videos.
I'm gonna try one more time.
The evidence in the 2015 case you heard about in your honor yourself in your ruling against me in the constitutional speedy trial argument noted the complex and thorough investigation of that case. There are witness after witness after witness that gave statements of varying degrees. There's several. I think you heard of one of them. Third.
All right, it's working, but yo, all right, we on Monkey right now, bro. Yo, we on Monkey right now. I'm trying to yo, what the fuck is that? Yo, these niggas are weird, bro. All right, I'm trying to. We probably just keep watching the case, bro. I probably gotta deal with this later. Yo, this nigga scared. He throwing up gang signs.
See something else like this.
Throwing up gang signs. Okay. Yo, it's really like I need somebody to make me laugh, bro. Like, what's up with niggas?
All right.
Give me some money.
I'm talking about from these people.
Look, you got a nigga right here for you. Look.
Yo.
Yeah.
Yo, bro, listen, yo, you on YouTube Live right now, yo.
Ah, shit.
You on YouTube Live, gang? What's your YouTube? Right now, what's your YouTube?
YT Playboy J.
All right, hold on.
So we live, bro. So listen, I got a question.
Hold on, babe. I want to find you.
Look your shit, gang.
All right, so listen.
Wait.
So what's one thing y'all niggas hate about females, bro?
Ooh.
Keep it a stack, bro. Like, yo, bro, listen. I'm gonna need y'all to get like, you know, like, get in depth, bro. Like disrespect.
What's your shit?
YT Playboy J.
They lie too much.
They lie too much?
Yeah.
They lie too much? That's cat. Them niggas
Yes, y'all do. Y'all lie too much.
Facts. Females do lie too much. That's all y'all do is lie for no reason. Like,
Word.
Why y'all lie for? He a best friend. He a brother.
Word.
He a brother.
But when we do something, it's a problem. But when they do something, it's not a problem.
We can't have no homegirls, no
You
nothing.
heard?
Y'all got a best friend. Oh,
Word.
he my ride or die. And
Word. He my fave. Like, fuck out of here.
bro, so listen, like, let me ask you. What do you hate about men?
Me?
Yeah.
She don't know.
She don't
That's
know.
all I do know. Wait, I need to pick one because there's a lot.
We low you. Look,
I
you
didn't
can't
be
even say
musty.
nothing. You can't even say nothing. We low you.
Yes, I do. These niggas be musty. That's all I got to say.
You said musty? Nah, that's it. Like, you don't got nothing else to say.
Oh, they're fucking toxic. They be trying to play these motherfucking girls.
What's the most toxic sign? What's the most quote unquote toxic sign? Because all this signs and shit y'all females be talking about.
Gemini.
I hate Gemini females. Terrible.
I'm not Gemini.
Hate Gemini females.
You a hater.
110%.
I hate Pisces females. Them bitches is K.
Bro, so what about, yo, fellas, so What about Leos, bro? I know I'm not the only one that hate Leos.
Nah, they weird. I ain't gonna lie.
Weird.
I'm smoking on them Leos.
They be thinking they the shit.
Yeah, real shit. But I appreciate y'all. Y'all niggas on live right now. Just go check out my YouTube. Y'all be on that.
All right, you too, gang.
Tight shit.
All right, bro.
Stay up, stay up.
Yo said Gemini gang, y'all tripping. Nah, yo, Gemini, I ain't gonna even lie. They not it. Niggas are in the bath and shit. Like, come on, bro. What's up with niggas? Yo, I got this freaking thing, bro. Yo, wait, we can have this play. We gonna put this on mute until I get some shit in for real. Yo, I'm trying to get on here, bro. Y'all see me on. Oh, I don't want to get T.O. wet. Oh. Yo, gang. This nigga, I was ready to flame his ass. I can't see. Oh, alright. They was not trying to let me skip. We're gonna keep that plan. Yo, why the I just realized. Yo, I'm trying to pack somebody, bro. I'm trying to get somebody's ass real quick. Yo, gang.
Yo, gang. Dance for me, gang.
Dance, bro. What the hell, no, gang? I'm on YouTube Live. I can't dance, bro. I'm gonna look like a munch. I can't dance, bro.
What you mean?
Bro, females don't like when niggas shake their hips. Only the Philly niggas allowed to do that
but
shit.
I ain't a female, you feel me? We some niggas in this bitch.
But right, but listen, I'm on YouTube Live and shit. I don't know, you know, I don't want my girl be watching, be like, you shaking your hips when a nigga say
bro,
so.
fuck all that shit. Twin, hit that shit, twin.
Bro, come on. Y'all got
Oh, so you from Baltimore.
Why you say that?
Yeah.
Why you say that?
I
am. What, I got an accent?
Hit it real quick. Hit it real quick.
Yo, bro, I can't, gang.
I need to see a block.
Nah, hell no. This nigga just told me hit the hips. Word of my mother? Nah, I was gonna be down bad if that nigga said, bro, that nigga said hit the hips. I couldn't go out like that. Couldn't go sad. Wow, that's what I said. I said, dude, that's terrible. Let me see if them niggas subscribe. Nigga said I said, dude, what type of shit? Call me real quick, babe. Call me real quick. Call my phone. Cause you still in here.
You gonna start coming more. Blue head open.
No. You all like no.
Severance. That may be correct in some other circumstances. The state doesn't concede that, but the fact of the matter is, it walks directly into the elephant in the room, which neither motion addresses in any way, which is the presence of count one, the RICO conspiracy count. There was no mention of that count in any of the arguments. It was simply not addressed, as though if it were ignored, it would somehow go away. Not one case cited by counsel for either movement is a RICO case. And so why does RICO change this? Well, it changes it for several reasons, but the first of which deals with the definition of pattern of racketeering activity. Because when, and I've made the point previously that a pattern is not an essential element of the conspiracy claim, but that doesn't mean it isn't relevant at all. That doesn't mean the state can't introduce evidence of it, because the actual commission of racketeering activity supports the inference of an agreement to engage in that activity. And the granddaddy case on that is United States versus Elliott, 571 F. 2nd, 880, a 1978 former Fifth Circuit case, which has subsequently, of course, when the Fifth and the 11th separated, when the 11th was created, that law became the 11th Circuit's law. The 11th Circuit has reaffirmed Elliott many, many times. So this evidence is relevant. And when you look at 1614.3, the definition section of RICO, subpart 4A, the definition of a pattern of racketeering activity, it says engaging in at least 2 acts of racketeering activity in furtherance of one or more incidents, schemes, or transactions that have the same or similar intents, results, accomplices, victims, or methods of commission, or otherwise are interrelated by distinguishing characteristics. In other words, that is exactly not the rule that the movants are relying on for severance. Here, every defendant is alleged to be an associate of YSL. When we look at these murders, and we look also at the attempted murders, which were not mentioned in the severance motion by Mr. Stilwell, every victim in the murders that are relevant to one or both of these movants was an associate of a rival gang. And so just saying these acts are unrelated doesn't make it so for the movants. We have gang associates killing gang associates, trying to kill gang associates. We have them getting arrested shortly after murders and attempted murders with weapons in their possession. And
I think he's farther in the case. We can go to this real quick. This nigga Bougie got AIDS.
You're still wrestling with your hair?
That's correct.
And, Your Honor, I do...
Is Ms. Hilton coming over?
I will ask her to come over right now, Your Honor.
That'd be wonderful. Okay. Is your witness here, sir?
Oh my gosh.
You told me yesterday having the afternoon.
K Lock, appreciate the $2.
Come right now.
Okay, that's fine.
I got your cash app.
Judge, can I
put you in
make an
twice, I
inquiry?
got you.
Understand. I see that his Mr. Nichols, this is Bruce Harvey
Crenshaw.
on behalf of Mr. Nichols. What's that?
You're the back door. I already said I recessed. I'm gonna recess to find out about him, okay?
Yeah, Bristol, I seen your ID.
I understand that, but what I wanted to inquire was whether he left the booth during
Judge, Mr. Harvey, Judge.
Prince,
yes,
I
Mr.
got
Chairman.
you.
Judge Glanville, I just sent you an email concerning
Avery.
Mr. Nichols. So if you want to make that
K-Lock,
announcement, that's fine.
That.
Okay, I wanted to know whether he was present for the argument.
Prince.
No, Mr. Harvey. Mr. Harvey, he wasn't present for that argument.
Okay.
And we just got indication as to what's going on with him.
Okay, thank you. That's what I wanted to inquire about.
That's fine, sir.
Howard.
Mr. Chamberlain, why don't you offline tell Mr. Harvey what's going on with Mr. Nichols, okay?
I'll call him.
Okay.
All right.
We'll call you and let you know. It's
Where's everybody from in the chat?
he's going to medical at this point in time, Mr. Harvey. So I'll need to talk with you about what's next steps, okay?
Yes, sir.
All right, thank you, sir.
Y'all let me know where y'all from.
I'm going to be in recess, and we'll be in recess
You back
until
in
such time.
recess.
Give me about
Chicago.
15 minutes, okay?
Your Honor, is there
Certain.
any reason that we need to keep Dr. Sim Stanley here?
No.
Okay.
No, she can be released. I said, excused her. Yes. Okay.
All right, let me go back to the state. Certain. Bassiana, got you. Breezy, I got you. Y'all from Jersey, St. Louis, California, Atlanta, Michigan, Virginia, North Carolina, Ohio, New York, Duval, Miami. Big play, appreciate that sub. Brooklyn, New York. What part of Brooklyn, New York you from? Fall Rock. Brooklyn, the best borough. Just putting it out there.
You know what I mean?
Fall Rock. How long is this freaking whatchamacallit? Oh, come back on.
He left the cell.
This is the freaking This is the whatchamacallit. I'm from Tokyo. This is the live stream from yesterday. What they do is they don't live stream the courts no more. What they do is they live stream like all day, like pre-recorded, and then they drop it at like midnight sometime. I don't know, I be asleep. So they drop it like at nighttime, midnight, 1 o'clock in the morning. So this is the video, the live stream from yesterday technically, you feel me? Harlem, New York. Wait, what happened? Wait. England. You're from England, Detroit, 7 Mile, Jersey. Oh my gosh, we got a $1 donut from Cutthroat Kimmy. Appreciate that. Cutthroat is going crazy. You know what I'm saying?
Yo, I'm
Jersey,
breaking the
Harlem.
stream.
Damn, bro, you ain't say
Tight
that.
shit.